Hello and welcome back to Coin Lady channel. Looks like we XRP holders are about to get our due. After filing a motion to have the Bill Hinman documents kept secret, the SEC lost the lawsuit with Ripple and Judge Torres. For certain. I don't think an introduction is necessary at this stage. The SEC requested that all emails and documentation related to the Ethereum free pass speech be kept secret. Yesterday evening, the long-awaited news broke that Judge Torres had ruled against the SEC. In the end, Judge Torres sided with Ripple. The market seems to have taken that as a hint, and XRP holders have followed suit. I'll explain why in this video. Many in the market viewed this as a sign that Judge Torres was leaning toward a ruling that would be positive for XRP investors if not Ripple. I think this is a reasonable assumption to make. As a result, the value of XRP shot up dramatically. Actually, XRP prices rose. Very quickly, it was reduced to something like 9 or 10%. Keep in mind that this is in no way a resounding victory for the SEC. This is related to the Hinman papers, and yet the market still jumped. It's intriguing to think about what might happen when the unbelievable news is announced. What we imagine and wish for. Additionally, XRP can develop further in tertiary markets. The potential price spike is terrifying to think about. As a result, it was exciting to watch prices rise. As time has passed, some of it has been recovered. But dude, this time the deck is stacked against you. Okay, here are a few things that we'll talk about. This is incredibly fascinating and unbelievable information, so I thought I'd share. Attorney Jeremy Hogan has stated that he believes the SEC will feel more pressure to settle because of this. It seems likely that Judge Torres has already drafted the summary judgment ruling, as both Attorney Hogan and Attorney Rispoli believe this to be the case. It's possible that this implies double-checking everything or simply making sure that everything has been done. But they believe there's a good chance it's already over, which means we're even more exceptional than usual, right at the finish line. As though it was simply inevitable. Also, I thought it was really cool to see this. An ex-SEC lawyer who has been advocating for the agency. This is unusual but understandable. I believe this man to be intellectually forthright. However, he claims that this latest development is evidence that Judge Torres will not rule in favor of the SEC. That's a new thing from him to say. To the contrary, he had been arguing the opposite. As a result, people are interpreting this in a wide variety of ways. Most observers of this story and document have concluded that Judge Torres' summary judgment ruling will not be favorable to the SEC. Don't misunderstand me, this doesn't mean that Ripple is guaranteed success. The SEC, however, finds that unlikely. They probably won't succeed in getting what they desire. But before I go into further detail and give the opinions of various people on this topic, I do want to clarify something. I have zero experience in either the law or finance. You should not buy or sell anything based on what I say or write because I am not a legal or financial advisor. For fun and as a pastime, I enjoy making videos about crypto-related topics to share on YouTube. This is it then? It's unusual for news to spread so quickly and widely, but that's exactly what happened when attorney James Phelan, a member of the XRP community, and I announced the news yesterday evening. However, almost 2.5 million people have now seen this developing story. Now, since this is being recorded, it is Wednesday, May 17th, right? It's the 17th of May, so yeah. Wednesday at this hour is 5:45 in the morning. It's been just over 12 hours, almost 13 hours, and 2.4 million individuals have signed up so far. So, this is what he posted on Twitter. Judge Torres has ruled that the SEC's request to have the Hinman documents kept secret would be denied. Even more exciting for you is the fact that Ripple has had access to these files for the better part of a year. Do you still have this tweet from the 20th of October? Just a quick review before we go. Hello, I'm Stuart Alderati. This is Ripple's top lawyer, the chief legal officer. On October 20th, he tweeted the following. After waiting for the Hinman files for nearly 18 months and receiving 6 court orders in 2022, we now have access to them. emails from within the SEC, and early versions of his controversial 2018 address. While the SEC has insisted that their existence be kept secret for the time being, the struggle I put in to acquire them was absolutely worthwhile. I've always had faith in our legal arguments, but now I have even more confidence. The SEC's tactics have always bothered me, but now I dislike them much more. That's why we've been curious. We've been wondering, what exactly is this? Is there anything that could be used to clear you of blame? For the simple reason that Judge Torres is undoubtedly knowledgeable on this subject. After reviewing everything, she has concluded that it is not confidential and has decided to suck at SEC. She has not been consistently finding in favor of the SEC, but it is not because of any inherent bias on her part. The SEC is making a monumental mistake by taking this stance. It's been made clear to Judge Torres that just because Ripple wants something doesn't guarantee they'll get it. However, even taking into account the SEC's previous judgment from the beginning of March with all of the expert witnesses, this is a big win for Ripple. The SEC suffered significant losses, including the testimony of key experts, when the judge refused to hear their case. The SEC would like you to believe that it values disclosure, transparency, and clarity, according to a tweet posted by Brad Garlinghouse on October 20 of last year. Ignore what they say. The dishonorable nature of their actions, once revealed, will stun you. Well, people, we're getting it, and we're getting that data shortly. Let's hear what Brad Garlinghouse had to say about it last night. He reposted the breaking news of the attorney's filing on Twitter. Uncensored versions of the Hinman emails, as reported by Brad Garlinghouse, represent yet another victory for open government. Keep an eye out as the attorneys figure out how to make that happen. Fox Business reporter Alina Terrett shared her insights on the topic of the mechanics of it all, as she has access to relevant information. Quite a few people have heard from her. And this is what she had to say about the method she described in her paper. In other words, Judge Torres has ruled against the SEC's request to keep the Hinman documents under wraps. Next steps. My legal advisors tell me that the next stage is for both sides to sit down and work out the details of when and how the documents will be made public. Does the SEC plan to make an attempt to file an interlocutory appeal? Possibly. Given that this is a discovery issue, however, the likelihood of Torres granting such a motion is low. And even if the SEC did try to appeal, it's quite unlikely that she'd agree to halt the release of the information as required by her order. We must now patiently wait. Let's hope she's right, even if it means waiting a little longer. I'm crossing my fingers that the judge will tell the SEC to take a hike if they try to fight this. I'm only interested in hearing that. It's nothing major, you did see women. Okay, that settles it. Just that is my desire? Is that really too much to ask? It's been too long already. What did he say, or what were the 6 court orders, as Stuart Alderati asked in October of last year? There were 6 edicts from the courts. After much resistance, the Hinman files eventually reached Ripple's upper management. There are now 6 judicial mandates. This also comes into play. And then this happened. That truly annoys me to no end. Want to give it some thought, kid? Here's a different take on things from lawyer James Murphy, aka the Meta Lawman on Twitter. And to the following he sent a letter. Gary Gensler now needs to worry that all of his email notes and memoranda on his contradictory statements on the SEC's ability to regulate crypto exchanges would be made public if the SEC sues Coinbase, as a result of the ruling enabling release of the Hinman document. That's an interesting nuance to think about. Here we finally have it. This was a pleasant surprise, and I appreciated it all the more for it. I do think that Mark Farrell, the ex-attorney for the SEC, is being intellectually forthright. As for John Reed Stark, I have my doubts. In my opinion, he often speaks incoherently. I find it hard to think that he seriously considers that psychedelic proverb to be true. However, Mark Farrell is an ex-attorney for the SEC. He has decided that Ripple is incorrect and is stating his case. For the reasons I've already stated, I've featured some of his videos on my channel. Many of his points of view are just not shared by me. That's okay, though. Such things like polite debate, back and forth, and the exchange of ideas are all good. To begin, it is worth noting that attorney Bill Morgan, a member of the XRP community, retweeted the breaking news from attorney filing and said, "Overall, I think the decision bodes well for Ripple on the summary judgment motions." Mark Farrell, a former attorney for the Securities and Exchange Commission, now weighs in and seems to concur. He concluded that the court was not likely to make more papers public if it intended to grant the SEC's application. You've even got the ex-SEC man who is pro-SEC and believes Ripple's in the wrong here saying, "Yeah, this don't look good for the SEC now that I actually loved reading here. I was like, when I read it." After one king claimed those documents are going to be very bad for SEC, presumably so, was the response from attorney Farrell. So, yes, he does agree. Perhaps, he says. And then he elaborates on that idea. And he replies, "I think it's an issue of whether they're really awful, as in evidence of ill faith, as many here presume, or just humiliating/legally problematic, as in a change in policy or internal confusion, as seems more plausible." Well, I can't say for certain which one it will be. Sure, that must be one of those. I doubt Brad Garlinghouse would have used the word shocking if it weren't something quite serious, given what he stated about it. To be perfectly honest, I anticipate a rather horrible surprise inside. And you can bet that I'll be writing about it as soon as it hits the shelves. There will be a lot to dissect in the days ahead, and I mean that literally. I'm simply providing you some of the initial comments from people like Brad Garlinghouse and Stuart Aldridge, as well as attorneys working in this area. A great deal more has to be explained about this. A lot rides on this. Here's what lawyer John Deaton has to say about it. Together with Enable Oversights, Strive for Openness, he penned this. A century after the statement, "Sunlight is said to be the best of disinfectants," was made by former Supreme Court Justice Louis Brandeis, we will all finally understand why this is true. I'm quoting. Yeah, that's a quote I've always enjoyed. I couldn't place its origin. Transparency is a pretty damn good thing, and I just see a shorthand version of that employed constantly in current politics. Here's something from Jeremy Hogan, an attorney, and things start to get interesting. In this tweet, attorney Hogan simply stated, "Judge Torres equals the people's judge." What follows is an excerpt from Judge Torres' ruling, which he also provided to the court. The court disagrees. The Hinman speech documents are judicial documents subject to a strong presumption of public access because they are relevant to the performance of the judicial function and useful in the judicial process, regardless of whether the court ultimately determines that the documents are admissible or whether the court relies on the documents in ruling on summary judgment motions. The court's decision on a motion could be affected by the Hinman speech records. The presumption of correctness in deciding a motion is not adjusted by the degree to which various documents were relied upon. According to Judge Netburn's order from January 13, 2022, the court does not buy the SEC claim that sealing is required to maintain internal transparency. Since the Hinman speech materials are unrelated to any agency position, decision, or policy, the deliberative process privilege does not apply to them. Bam. Absolutely. My interest is piqued. Here, honesty is of the first importance. And as an attorney, former SEC attorney Mark Fedger pointed out, if this is about to be a slam dunk for the SEC, why is she bothering with this coming out? Well, it turns out there is some conjecture from a couple of lawyers about this. Attorneys Hogan and Rispoli speculate that the case's resolution may depend on Judge Torres' summary judgment ruling. The stage has been set. And I've wondered that previously, because how could you get to the end of the draft if she has no idea what she's going to do in the big picture? That's something I've been saying for a while. Solicitor Hogan also divulged this information. He questioned whether anyone else had the impression, after reading the SEC's order on the sealing earlier today, that a sizable chunk of the order on summary judgment had already been written. Anyone? Bueller. Indeed, that is the correct response. What follows is a portion of what the screen capture showed. I'll just begin where I'm now, in this circle. Even though Garlinghouse is a party to this action, the court finds that Ripple's business secrecy interest and Garlinghouse's personal privacy interest justify narrowly tailored redactions to his compensation information, which is minimally relevant to the court's decision on the summary judgment motions, as written by Judge Torres here. That last sentence, restated, is what the court should focus on when deciding whether or not to grant the parties' summary judgment applications. I believe that this is the direction Attorney Hogan was thinking, thus her choice of phrasing. Maybe she already written the damn thing and knows it's just marginally important, in which case it will be good for Ripple. In a separate but related note, he emphasized the following sentence, because the substance of these settlement agreements have minimal significance to the summary judgment motions. Again, it's easy to see why Attorney Hogan would question if this is a sign that summary judgment has been reached. So once again, maybe by crossing our fingers, or TS, or just making sure everything is in order, we'll receive it. This might happen at any time now. I know we've been saying it for a while, but I believe it's more true now, not only because more time has passed, but because look at the tone of all this material, and look at how this came out. Simply fantastic. It's true. Take a look at what XRP community member and lawyer Fred Rispoli has to say. He then penned the following fiery opinion. The summary judgment ruling is obviously written, possibly done, possibly requiring minor touches. I know I've been saying this for a while, but any day now is the day. Aside from the finding about the Hinman email, there is nothing particularly shocking about this ruling. A total Ripple win would have given Judge Torres an excuse to not order production, so this is both good and terrible news. Similarly, with SEC. Not saying either can't win by a slim margin, but I stand by my prediction that both have slim chances. Possibly force SEC to reach a settlement. Yes. But I believe the secret is out on these records and that if not here in Ripple, some enforcement case would have gotten them publicly published. This decision, however, seems to favor Ripple. We can only hope that this holds true in the summary judgment decision. That's the prevailing consensus in the markets, I guess, which is why I mentioned XRP sudden, dramatic price increase a second time, somewhere between 9 and 10%. Since then, it has decreased somewhat, but it is still higher than it was before. Not only did I fail, but I should probably go back and mention it. Let me say that I'm relieved I had this idea now, because Attorney Rispoli also made a related remark. Diamond Hands wrote to Attorney Hogan asking, Jeremy, do you think this increases the pressure on the SEC to settle? Yes, of course, Attorney Hogan emailed. And that's not all, either. And, I've been doubtful of a clear victory for either side. Not that I'm aware of. Since I'm not a lawyer, my confidence in this matter isn't as high as that of the lawyers who have made public wagers on it. If, however, XRP holders are adequately safeguarded, for example, by ensuring that secondary market transactions continue to be allowed, as they clearly should be, even if Ripple technically loses in any capacity, this might still be a tremendous gain for XRP holders. I also think it's important that Ripple be able to purchase and sell XRP on secondary markets like everyone else. Absolutely. I'm aware that they have. Even if all the deals that have been made in the past few years have involved instantaneous cash, you can still see how I roll. They should be allowed to keep doing that without question. There really shouldn't be any roadblocks to that. Again, I'm optimistic since all this has done for me is to give me a smidgen more confidence. And I think it very well sums up how most of us feel right now. So, let's see how this plays out. This is the foundational knowledge I wish to impart to you about the issue. But again, in the days to come, there will be much more to discuss. There's too much to explain in anything less than a 3-hour film. So, I figured this would serve as a decent introduction. Share the opinions of several local attorneys with you. But, no, the SEC is not going to have an easy go of it here. At the end of the day, I think this is positive news for XRP investors, but I have no idea how the price will react. But I'll end this for the time being. No, I don't give out financial advice. Nothing I say or write should be used as a basis for making financial decisions. Please like and subscribe my channel if you enjoyed it. See you later, bye.